Hello and welcome to the Great Plan Moody webinar starting today on what franchisors need to know about the California Consumer Privacy Act. This is Galen Knack from Great Plan, and I've got just a few administrative items to quickly go over before we get started. First of all, we are encouraging people to ask questions during the session, and depending on the number, we will try to answer those as we go through our webinar today. Depending on time, we'll also save time at the end. Otherwise, we will be happy to follow up with you. Please use the chat feature by clicking on the Send Questions Here bar in order to ask a question. Also, we're recording this session, and we'll make this available on our website, and we'll follow up with an email with a link to the webinar recording. And with that, let's get started. First of all, I'm going to let you know what we're going to cover today. Obviously, there's been a lot of discussion about the CCPA, and there's a lot of detail, and many webinars have already taken place that focus on the mechanics, consumer rights. We're going to briefly cover that today, but our goal today is not to go into detail with that segment because we want to save time during this hour to focus on the other two parts, and that is unique concerns for franchise systems and, importantly, action items for franchisors. Today, I want to welcome my fellow panelists, Mike Cohen and Amanda McAllister. They're my privacy experts that are going to be guiding us through what is a challenging subject for franchisors. And with that, I'm going to turn it over to Mike to give us a brief overview on the California Consumer Privacy Act.
Thank you, Galen, and I want to welcome everyone to our webinar. You probably were just getting over the fatigue of GDPR, and Amanda and I have spent a good deal of our practice counseling clients on how they should be preparing and complying with that European law that everybody was hearing about. Many of you may have already gone through some compliance exercises with GDPR, or maybe took the position that that has to do with European residents, so I really don't have to worry about it. Well, now you have to worry about it a little bit because the enhanced rights that were given European residents have now come across the pond, and California residents are going to be enjoying these data privacy rights under this new California law. And I thought I'd just spend a minute making sure you understand how this happened, because it really came out of nowhere. Just after the GDPR went into effect, May 25th of 2018, we started to hearing about this citizens initiative that had already been underway in California, that was started by a wealthy individual by the name of Alistair McTaggart. And it sounds like a joke, but he walked into a California bar and met with a Google employee and asked him, so what do you do with, what happens with my data? And he was so horrified to find out that Google actually monetized his data and sold it to others. So he started the Citizens Initiative that would have actually ended up on the November ballot in California, and got everybody upset and concerned about what new rights California residents would have. And the California legislature decided to circumvent that effort, and working with McTaggart and others, in less than a week's time, passed this California Consumer Privacy Act. It's actually the California Consumer Privacy Act of 2018, because that's when it was initially passed. There was a lot of thought that this law might go away. There might be a new federal law that would replace it. Technology companies were going to lobby to the point where it would disappear. And again, hopefully you weren't one of those businesses that said, I don't have to worry about it, because as we're getting closer to the effective date, which is less than 60 days away, we're going to have to deal with what it's going to provide, which is new consumer rights that California residents will have relative to their ability to access to their personal data, their ability to have it deleted and sharing it with others. There's specific disclosure requirements that are required, and the Attorney General was tasked with finalizing regulations that would provide more guidance to businesses by July 2020. So as Galen had mentioned, there's been a lot of webinars already that have gotten into, the details and the mechanics, I would say, of the CCPA relative to dealing with consumer requests. And while I think that's very important, and we are going to cover that, to some extent, I think what has not been getting as much attention, and what I believe is probably the most important part of the CCPA, because we've never seen this before in any other data privacy law, and that is that there is going to be the ability to bring private right of actions, and it's limited, however, to the failure of a business to have data security. There were, and maybe you can get some comfort in this, there were some thoughts and efforts to have the private right of action apply to any violation of the CCPA, but now we're only limited to a concern about data security. And that's why I think that should be at the top of your list, and that's why we're going to spend a good deal of time talking about that today.
Okay, Amanda, can you give us a brief overview of some of the basic consumer privacy rights under the CCPA?
Yeah, so under the CCPA, consumers will now have more say in how their data is treated and used by a business. The rights provided under the CCPA are the right to know, the right to access, the right to opt out, and the right to request deletion. So let's go over each of these briefly. The right to know requires businesses to inform consumers at or before the point of collection what types of personal information will be collected and the purposes for which that personal information will be used. The right to access requires businesses to disclose to consumers the categories and specific pieces of personal information that they collect about a consumer, the source from which that data is collected, and to whom that data is shared or sold, covering the past 12 months. Consumers also have the right to request deletion of their personal information, and this is kind of similar to the right to erasure under the GDPR in some ways. This right is not absolute, and it's subject to several exceptions. Further, this right does not just apply to information that's held by the business, but it also extends to information that would be held by your service providers. And finally, consumers also have the right to opt out by directing a business that sells his or her personal information to third parties to cease that practice. So subsequent to that request, there can be no discrimination against consumers for opting out of the sale of their personal information.
So Amanda, you mentioned the right to opt out of sale, and consumers have this new right. To me, when I think of the sale of personal information, I go back to Mike's comment about Google. Obviously, companies like Google and others may sell, but really, it seems narrow and wouldn't seem to apply to most franchisors and their franchise systems. Am I reading that correctly?
Well, yeah, when we hear the word sell, many of us think of just this traditional sale of or monetizing of data. But the definition of sale under the CCPA is actually much broader than that. It includes selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating orally, in writing, or by electronic or other means a consumer's personal information to another business or third party for monetary or other valuable consideration. So it's this last part, for valuable consideration, that significantly expands the definition of sale. But the term valuable consideration itself is not defined under the CCPA, and the Attorney General has not yet provided additional guidance on what this term means.
Okay, so clearly it does sound like it is much broader than just the word sale. Can you, Amanda, briefly just talk about this big word of operationalizing, which is too big of a word for me, but what do you mean by that? And basically, what are some of the things that are required as a result of these new consumer rights?
Yeah, so in order to put these new rights into practice, businesses will need to do a few things. First, businesses subject to the CCPA will likely have to update their privacy policies and disclosures. The CCPA requires privacy notices to disclose categories of personal information that are collected and the purposes for which that data is collected. And privacy policies should also include the information about these consumer rights we've just discussed under the CCPA and how consumers can exercise those rights in their privacy policies. Consumers must submit verifiable requests to exercise these rights, and the verification of these requests is going to be important to prevent the unauthorized disclosure of personal information. And further, businesses must have processes and procedures in place to respond to these consumer requests. These procedures should include this verification of the identity of the consumer, potential analysis of whether an exception might apply, such as in the right for deletion, and it should enable an organization to respond to the consumer request within 45 days, which is the time frame required by the CCPA.
Thank you, Amanda. Mike, as we move forward, obviously you mentioned a little bit of the background on the passage of the CCPA and the fact that it took place with little or no time to really debate the issues. What has happened since then in terms of developments since 2018?
Yeah, Gail, and as I mentioned, this was done in less than a week, so you can imagine what that law looked like. There were a lot of inconsistencies and things that just really didn't make sense. So there was a lot of cleanup. I think there was also some hope that in the course of the legislature meeting and the lobbying that was going to go on, that there might have been more drastic changes or substantive changes to the act from when it was first passed in 2018, and we really didn't see the kind of significant or substantive changes that many were looking for. And if I could just go back for just to make sure that the audience understands you know, how broad this new law is. And a lot of people are trying to compare it to GDPR, and I don't think that's really fair. I mean, there are some elements of that they have in common. But so, for example, even just the definition of personal information that is included in this act includes employees. And that was one that there was a lot of concern about if that was even going to stay in, and there was a hope that that was going to be removed from the act, and it did not. So there's employee information that's included. There's also important to know that there's a look back of 12 months. So even though the effective date is January 1st of 2020, the data that you collected 12 months before that January 1st date, so even as early as January 1st, 2019, could be covered under the Act. So I just think it's important for you to be aware of that 12-month look back, and also the broadness of the definition of personal information. So we didn't really hear very much from the legislature until October. It was really less than a month ago when there were amendments that were actually made to the CCPA. And it was interesting that the amendments were finally passed, and this was almost the last day of the legislative session. So it wasn't that long ago that they came out. And just shortly after that, the Attorney General's office issued their draft regulations. And the only real amendment, there were a number of amendments, again, that were clarifying and made some relatively minor changes. The two that were the most significant to the version that was passed in 2018 were one that it didn't remove employment-related data from the definition of personal information. One of the reasons that it wasn't removed, because there was almost consensus that employee data should not be included. I mean, this is called the Consumer Privacy Act, but the labor organizations in California labored very hard because they liked the idea that there were going to be some new rights that were going to be afforded employees. So as a compromise, what they decided to do was to say that they're not going to go after businesses and have them comply with the ability, giving employees the ability, for example, to pursue those data access requests that Amanda had talked about before, that the employees don't have those rights. But employees will have rights if you would be in breach, for example, of the data breach that we're going to be talking about shortly, and that you still need to provide them information about how their data is collected. But what they did as this part of this amendment, they said that this is only going to be an exemption for a period of 1 year, and they're tasking the California legislature to come up with a way to deal with employees as part of this Privacy Act. So it maybe goes away in some fashion for a year, but it hasn't been totally eliminated from the Act. So that was a major change from the 2018 version. The other was that they are allowing a limited exemption for just what we call B2B or business-to-business sharing of information. For example, in the course of due diligence acquisitions, if you're sharing information with a business for business purposes, they're going to allow that also to be carved out for 1 year. But just as they have that 1 year carve out for employment-related data in a limited fashion, it likewise, to the extent that there's a data breach that should occur and you have Social Security numbers, for example, of a business person that you're dealing with, they would be covered under that. So those were the amendments, and those were signed into law as part of the CCPA by the governor. And then the California Attorney General's office finally did release their proposed regulations on October 10th. So just a little over a month ago. And so again, these are draft regulations. The draft regulations are in total about 47 pages long, because they have not just the regulations that they're proposing, they also have discussion about why they are proposing them in the fashion that they are. There are going to be public hearings held very soon, with the last ability to comment in writing set for December 6th. So these are all in process right now, but it's extremely important for you to be understanding what these rules are saying, and there is an effort to give some guidance to businesses relative to how the CCPA will actually be implemented.
Mike, based on that, and part of the reason for having difficulty in mucking through the act itself and its impact on franchisors is the fact that these proposed regulations just came out in the last few weeks. Can you highlight just a couple of the key items that have come up in the proposed regulations?
Sure. So what the regulations, the purpose was, again, to give more guidance and add some detail to the act itself. And in doing that, what they made an effort to provide some more guidance as to what should be included in the notices that consumers are receiving. I think there was a bit of a surprise, though, when people started reading the regulations and saw that the Attorney General's office was very specific in noting that this law does not just apply to notices that must be given to consumers in the online environment, but there have to be notices given to the extent that you're collecting any data from a consumer at the point of collection. So theoretically, if somebody walks into your store and you start collecting information from them, and it might not be through your point of purchase system, but even with pencil and paper, theoretically, you have to give them notice. So there has to be a notice given not just online but offline. So the regulation actually goes into some detail explaining how it's important for you to have both the online and the offline collection of information.
So, Mike, I walk into a coffee shop in California, obviously now later in 2020, after the regs are in place, and somebody asks if I'm a member of their loyalty club, and I say I'm not, and they ask me if I want to sign up. Is that alone going to then require there to be some signage at the checkout counter where I'm getting my coffee?
Well, that's right. There has to be some consideration of what type of notice should be given. And so what people are considering now is again, these are draft regulations. So if that actually does come to fruition, then the idea is that you would give them a piece of paper or a card, and actually what you could do is if you do have an online privacy policy, it could give them the website so they can go and see what their rights are. But you do need to give them some notification. The regs also go into some detail about the processes that a business should go through in order to verify requests. One thing that is really important to understand is you could be in a worse situation if you simply respond quickly without verification to a request comes in for personal information. There was an interesting study done by a graduate student who decided under the GDPR he was going to find out all the information he could from companies about his fiancée. He had no real right to do that, but it was amazing how many companies very quickly disclosed that personal information to him on a simple request. So the Attorney General's office has actually spent some time in putting some detail together about the need that the process you should go through for verification purposes. The other thing, and this is important for franchisors to understand, and that is that there are specific training obligations under the CCPA, and those training obligations are also detailed in the regulations and require you, for example, to do it once a year, and also to keep records. And the record keeping doesn't just extend to the training. You need to keep records for 24 months of all the consumer requests that are coming in. So there's a record keeping requirement also that's detailed in the regulations.
Mike, with all of these requirements that are proposed or are in the statute itself, California legislature have any sense as to what this is going to cost, not just franchisors and their franchisees in California, but other businesses as well?
Yeah, Gail, as I mentioned, the regs when they came out are 47 pages long. I'd say there's probably about 20 pages that is a very interesting and detailed economic assessment of the CCPA itself. and they engaged a consultant to conduct a study, and they went into great detail about what they thought the cost would be. They actually saw some benefits, you know, in terms of the impact on privacy rights, but they determined that the cost of compliance for the CCPA over the next 10 years could actually, you know, reach almost $16.5 billion. Now, when they looked at these costs of compliance, they looked at it in 4 buckets. You know, first were the legal costs. That would be hiring people like ourselves or to come in and help you interpret, which was a very confusing law to begin with. Then there's the operational aspect, you know, that you'll have to establish non-technical infrastructure to deal with compliance. The technical part of it, you might need new system software to respond to these consumer requests. And then just the business decisions. You might have to make different decisions as to how you're going to collect and share information, and also be looking at your service provider agreements.
So Mike, questions that I've already heard from a number of franchisors is obviously the act goes into place January 1. The California Attorney General has been given broad enforcement powers. We'll deal with private causes of action in a little bit, but focusing in on the California Attorney General and their enforcement powers, when can they really start aggressively enforcing it? Is it January 1 of this next year, or is it July 1? Give us a little insight on that, Mike.
So the act goes into effect January 1st of 2020, but they are not going to be able to enforce the act. The Attorney General's office isn't going to be able to take actions until 6 months after the regulations have been finalized, or July 1st, 2020, whichever comes first. So if you figure out on your calendar when those enforcement actions are likely to take place, we're really looking at the thought is that they're probably not even going to finalize these regulations until maybe spring of next year. But even if they did, they're not going to be able to enforce them until, you know, the enforcement will take place, like I said, July 1st, 2020 would be the earliest.
And these fines of $2,500 per violation or $7,500 for an intentional violation, I would imagine because of the amount of data that gets collected by a given company that these numbers can add up pretty quickly.
Oh, absolutely. It's very, very easy to see if you look at the number of individuals and their records that might be compromised or not that where there's been a violation. I will say that my experience generally with enforcement, whether it's from an Attorney General or the FTC, have been fairly limited just because they tend to be under-resourced and both in terms of people and funds to go after companies. But what we're really concerned about, and not to say it won't happen, is this new private right of action.
Yeah, so Mike and I and others have talked about California, and probably the biggest worry out there for franchisors and their franchise systems is, yes, there are a lot of mechanics. There's a lot of detail in terms of making sure that consumers have their rights as to their own data. But in terms of the overall enterprise risk to a franchisor, we believe that by far the biggest concern is the private cause of action that is given as it relates to a data breach. And as everybody is aware, no matter how much time and effort and money you spend to try to secure your systems, there are some very smart, intelligent criminals out there that have found ways to hack systems and get access to data. And we're well aware of the many companies that have been forced to deal with a data breach situation. So with that, Mike, explain how a data breach that takes place here after January 1 of 2020 can turn into significant liability for a franchisor and its franchise system.
Sure. So, you know, as Galen identified for you, we live in a world where, you know, data breaches have become almost a daily occurrence. And it's something that, you know, businesses most are very aware of and concerned about. But for the most part, when there's been a data breach that's occurred, you've had to deal with, you know, the possibility that maybe there'd be, you know, you get a notice from the Attorney General's office. You'd have some notice requirements that you'd have to notify the AG's office or individuals. And this is a game changer by including in the CCPA the right that an individual has to bring a lawsuit, or in the case where a lawyer was able to get enough people to constitute a class, which, you know, when these data breaches occur, they occur across the board, and so there are a lot of individuals that are going to be involved. So it's not too difficult to see those class actions being created. And the way it works under the CCPA is if there's unauthorized access, theft, or disclosure of a consumer's, and this is really important, it's data that's non-encrypted or non-redacted. And the reason that's important because if you can demonstrate that your data is encrypted or it's redacted, that might be your get-out-of-jail-free card. So it's important for you to recognize that. But if that data breach under that definition has occurred, and it's determined that the breach itself was the result of your failure to implement and maintain, and the term is reasonable security. So if you don't have reasonable data security, then that's what triggers the ability to bring that lawsuit. There is an opportunity, and there's been some question about how that's going to be implemented. You have to give the company a 30-day notice to cure that data breach. But still, the dollar amounts are significant because this isn't just a situation now where the lawyer has to prove damages. They now have what are called statutory damages. So all they need to do is demonstrate that the breach has occurred, that you didn't have reasonable security in place, and then they're entitled to up to $750 per violation. So if you do the math, if there are 50,000 California consumers that are involved in a data breach, you're looking at a claim of $37.5 million. So I can promise you that there are lawyers that are already waiting for January 1 and to be prepared because this is going to be a gold mine for plaintiffs' lawyers to go after businesses, very similar to what happened under the Telephone Consumer Protection Act, the TCPA. And franchisors were a target there. They went after Domino's and Pizza Hut and other franchisors because you know, the numbers are significant and the damages are extremely high potentially.
So, Mike, before we leave this slide, as I look at this, I see some phrases up there: non-encrypted, non-redacted, reasonable security procedures, this idea of failure to cure. They seem like somewhat nebulous terms. Is there any more guidance so far in terms of what these mean? Or is this going to really be battled out in the courts in terms of how to interpret these phrases?
Well, those are very good questions. Again, this is new. There hasn't been a single case yet brought. So And this question of what is reasonable security has been an ongoing issue in privacy and data security areas. And one of the thoughts, even in crafting these laws, is should you be very prescriptive and say what is reasonable security, or just use that term? So there is going to be interesting efforts to try and determine what that is. But we wouldn't be doing our job if we didn't try to give you some guidance in this area. And so what I think is really important is for you to make an effort where, even though the CCPA does not define what reasonable data security is, we are looking at California. So I think it's very useful to look at what the California Attorney General's office has said in the past. And they actually, a few years ago, there was a woman by the name of Kamala Harris, that you may have heard of, who's now running for president, who, when she was the Attorney General, issued a report. And in that report, they specifically identified the security procedures that under the Center for the Internet Security Controls, and that could be followed as a possible standard. The thing about, I just want to mention about that real quickly, is that in those controls, some of the elements that they include are having a written information security program, having an incident response plan, vendor management, and other things that we think are really key to having your business be deemed to have reasonable data security.
Okay. Amanda, obviously, with this private cause of action and with the threat of enforcement by the California Attorney General, there's the potential for serious liability for failure to comply. And there's been some discussion about how does CCPA apply to franchisors. Maybe you can briefly take us through that so that we understand how it does apply to franchisors.
Yep, so the CCPA will apply to any franchisor that's doing business in California and meets any of the following thresholds. 1, annual gross revenues of $25 million. 2, buys, sells, receives, or shares the personal information of more than 50,000 California residents, households, or devices for commercial purposes annually. So that's another example of the CCPA taking a really broad approach, where this is not just California residents, but households and devices as well. And 3, derives 50% or more of its annual revenue from selling California residents' personal information. So again, you need to be doing business in California and meet just one of these 3 thresholds. So, and a business that's subject to the CCPA will also include any entity that controls or is controlled by that business and shares common branding with that business. So here's where the definition starts to invoke a potential franchise system. The definition of control is still vague, but it includes the phrase controlling influence over the management of a company. So the definition of business and control together really opens the door to a potential claim that the CCPA is meant to cover an entire franchise system if either the franchisee or franchisor meets the definition of a covered business under the CCPA.
So Amanda, when we think of control from a franchisor standpoint, franchisors are always careful to say we don't control our franchisees. We allow them to manage the day-to-day operations. But the way you explained it here, it seems to go far beyond just our normal ideas of the word control or controlling. And I'm concerned about this common branding and the power to exercise a controlling influence over management. As a result, I think a lot of us have concluded that all but maybe the smallest franchisors are likely going to be subject to the CCPA. It also will bring within its scope California franchisees in most cases, and it might even include franchisees located outside of California to the extent that they hit one of those 3 prongs that you just mentioned. So it does seem like, from a standpoint of the scope, that we are talking about most franchisors in this case, correct?
Yes, that's correct. A lot of the terminology under the CCPA really shouldn't be taken on its face, because when we look at the definitions, they're actually much broader than we might expect.
Okay. So if that's the case, and I think that certainly franchisors could argue that they may be able to avoid the need to comply with the CCPA by claiming they're not under control, but to be honest, because of the broad language involved, I'm not sure any franchisor wants to be that first effort to try to argue that the scope is narrow enough not to include them, especially given the potential for damages, whether it's through the AG's office or elsewise. As a result, if we're talking about this CCPA and all the requirements impacting franchisors, it's going to require franchisors to take a look at what personal data do we currently collect and on California residents. And I'm going to expand this one step further. We talk about California residents, but as we talk a little bit further before the end here, we've got other states looking at this as well. So franchisors, as we plan going forward, should not just be thinking of California, but we really need to be thinking of this more on a nationwide scope, because as we'll talk later, we expect to see more of this in other states. But we got to look at personal data, because right now today, franchisors and the franchisees are collecting various information, obviously from customers at the unit level, prospective franchisees in California, and we also, the franchisors, obtain personal information of franchisee principals and their employees. And it may be that we collect it directly, or it simply may be that the franchisor can access that information through the point of sale system that the franchisees have. A couple of things to think about as we talk through some of the concerns there on personal data is this whole idea of ownership. Franchisors, going back maybe 15 years when we started focusing on this, would claim ownership of the data in order to make sure that the franchisee at the end of the term of the agreement didn't walk off with a customer list and possibly use it to their benefit and to the harm of the franchisor. And so the franchisor in many franchise agreements will indicate that they own the data. And I think if you look at franchise agreement provisions that's consistent with that, perhaps the operations manual also talks about that. We will talk a little bit further about this whole idea of ownership, but certainly the CCPA requires franchisors now to take a closer look at how do we address it. How do we address policies on privacy and operations manuals and third-party access and use of that data? And that's going to lead us to our final phase of our webinar today, and that is what do franchisors and the executive team need to do in response to the CCPA to protect our brand? Obviously, customer data is important to varying degrees. Even to franchisors that do not rely as much on customer data still are going to need it to grow their business and for franchisees to grow theirs. For other franchisors, customer data is a very significant asset. If we think of loyalty programs that many brands are adopting, it's very important that we have some control over customer data to the extent possible. But in light of CCPA and this growing trend towards granting consumers greater rights, we got to look at specific action items that franchisors should be considering and taking in order to deal with this legislation, not just in California, but what we expect in other places. So Mike, given that, let's talk about some steps that franchisors can take, and specifically from an internal standpoint for the franchisor. And let's talk first maybe about privacy. We'll talk about privacy and website first, if you could, and also consumer requests, and then I'll bounce back to the franchise agreement.
Sure. So again, we're just looking now at from the franchisors, corporate offices and what they should be doing. And as I mentioned before, you're going to be looking at your privacy policy that is ubiquitous to just about every business that appears on your home website. And one consideration you might make is, do you want to have a new privacy policy that's going to apply to everyone, or are you going to add something that's just going to be kind of a standalone and separate that's going to deal with California for those people that are California residents? So that's just a consideration. Review and update your privacy policy, and to go back to make sure that you're complying with the need to respond to how are you going to handle consumer requests when those consumer requests, if they come in from your franchisees or if they come in directly from the consumer. You just need to be figuring out internally how you're going to be dealing with those and what procedures you have in place.
Okay. Then another action item is to take a look at your actual franchise agreements that deal with customer data, who's collecting it, what rights does the franchisee have with respect to that customer data, what rights does the franchisor have, and then obviously franchise agreements are for 5 or 10-year terms for many franchise systems, so you cannot be as nimble in terms of making changes constantly that impact the system, so you often have more general provisions in your franchise agreements, and you look to your operations manual to be able to update. And in an area like this with privacy, it's extremely important that franchisors have the flexibility to be able to make changes more often than what they see in their franchise agreement. So the operations manual becomes very important. And while we're on that topic, a question did come in from one of the listeners that talked about franchisor liability, specifically in a situation where a franchisee gets a request to delete customer information and doesn't do that or doesn't inform the franchisor of the request. So this is one of those situations where we could realistically see a franchisee in California, after the regulations are in effect, perhaps it's an employee of a franchisee that isn't totally informed as to what they need to do, and they just fail to comply. And the question is, the first question is, to what extent can a franchisor be liable in a situation like that? And Mike, obviously we're dealing with some terms in the statute that are fairly blurry at this time. Any thoughts in terms of that question?
Yeah, it's a good question. It gets to, how liable is the franchisor going to be for franchisee's actions. So that's a whole issue that you're certainly already familiar with within the franchisor-franchisee context. But just relative to the CCPA, there should be training that's going to go on to give the franchisees some guidance in terms of how they should be handling these requests when they come in. And there are different types of requests too. Is it a request to delete their data? Is it a request for mere access? So again, we're still kind of struggling with exactly the mechanics of how to deal with this, but it's an important question that's going to have to be sorted through by both the franchisor and the franchisees into how they're going to deal with the mechanics of implementing that.
There was a related question too as to who actually owns that customer information that tied into the question. And I think that most franchisors, maybe not all, but most franchisors are going to want to at least control how that customer data is being used. When we talk about ownership of it, and I know a lot of franchise agreements say that the franchisor owns the customer data. Actually, if we look at the CCPA, it's really the consumer that owns their data, and they have a right to determine how that data gets used. And so we do have to think through how we describe controls over use of customer data. If a franchisor is saying we own the customer data in the situation that was just asked, and a California franchisee fails to comply, I think that there would be a fairly easy tie for the California AG's office to be able to say that the franchisor has some responsibility here because it's coming out and saying that it owns the customer data. And so it's that type of concern that I think now requires franchisors to take a look back at their franchise agreements and their policies and determine how important is it for us to control the data. If it is important, then we have to look at some of the steps that have to be taken. We'll talk about that in a slide or two. But I'd like to turn, Mike, maybe the next slide. Obviously, a big concern for us is the threat of private causes of action and class action lawsuits where there's a data breach, and this whole issue of what is reasonable data security measures. Maybe you can give us a little guidance there on what franchisors should be doing.
Sure, and as I mentioned, the CCPA and other laws are not prescriptive. They don't say you have to have ISO certification or you have to follow the NIST framework. But at least we do in California, as I mentioned, we have that California Attorney General's Office's report that cites the Center for Internet Society controls. So I would look to make sure that you do follow some framework or standard. And you can either do it yourself if you have the appropriate skill set in your IT department, or engage a consultant. And believe me, there are a lot of consultants out there that are very busy these days helping businesses to get ready for the CCPA because of this concern over the private right of action. But some things that you can do very simply that we've been doing a lot of, and we've been doing even before the CCPA because it makes good sense, and that's to have a written information security program, otherwise known as a WISP. The Massachusetts state law requires you to have one if you collect personal information of any Massachusetts resident. So what we've done, what others have done, is you follow that format. So you kill two birds with one stone. You comply with the Massachusetts law, and you also have something that you can use for compliance purposes under the CCPA, and a written incident response plan. All that really is providing you a team that can, how you're going to approach a data breach when it occurs. If you can have those elements in a data security program that you document, that would be your best defense when the complaint comes in that, under the CCPA for your failure to have reasonable data security in place.
So leading into communications with franchisees and training, and just stepping back for a second, Mike, if we talk about reasonable data security measures, when we look at the California law, we're not just talking about the franchisor here, are we? We're also talking about the franchisees in California or others that are subject to it, correct?
That's right.
So if we are looking at a situation where the franchisor wants to maintain control over customer data through its franchise system, it needs to then look at the importance of franchisee communications and training. So it's important not just that the franchisor understands how to comply with the CCPA, but also ensuring that your franchisees comply. And that goes back to the question we had before as to what extent can a franchisor be liable if a California franchisee is not complying with the act. And I don't think franchisors want to be the test case to determine to what extent a franchisor will be held liable in that situation. And we're encouraging our clients to reach out, develop training sessions for franchisees Also, dovetailing on the reasonable security measures that the franchisor is taking, there should also be, to some extent, training on what the franchisee should be doing. All of that, of course, we have to balance the liability exposure. The more that you're getting involved in instructing franchisees as to how to comply with the Act, the more you understand the potential liability risk you're taking on by inserting yourself there. But the alternative is to let the franchisees on their own to determine how they're going to comply, and I'm not sure that's the wisest move for franchisors. Mike, briefly, cybersecurity insurance?
Yeah, it's just something to have in your toolkit would be cybersecurity insurance, but if I can make a commercial, I get no commission. Now's a good time to look into getting it before those premiums go way up and when those lawsuits start happening under the CCPA. So definitely something to consider.
Okay. A couple other things before we wrap it up here, Amanda and Mike. One thing that I think often gets overlooked is the whole idea of vendor management. Franchisors have contracts with vendors that provide IT services, various other types of services, and it's important to review all vendor contracts in which third parties have access to personal data. Among some of the other things, frankly, you want to make sure if a vendor has access to personal data that they get access to it only for the specific purpose for which they're conducting the service for you. You also, and this is very important, you want to make sure that you're not assuming liability in situations where a vendor has control over data and has not taken either adequate security measures or provided you with some protection, whether it be indemnification or having their own cybersecurity insurance. We oftentimes will see contracts that the vendor has provided that are not as friendly to the franchisor as to what is necessary for you to have limits on your exposure to violations of the CCPA. And then downstream, you may have customer contracts where a large national account customer may be looking to you to provide services, and you have access to their data, and you want to make sure that you're not over-promising what type of measures or security you're taking to them. So vendor management is extremely important and often an overlooked one. With that, we're down to just the last minute or two. I think one of the things that we want to hit on, Mike, is keeping current on the CCPA, because obviously we're still working within an environment that's not crystal clear, correct?
That's right. And, you know, if you, the value, I will say, of at least looking at the CCPA for compliance purposes is that it'll position you to be ready for what I think is likely that you're going to see a lot more of. You know, there are a lot of other states that have copycat bills that are identical to the CCPA, and so, you know, if you're going to be positioning yourself for compliance with the CCPA, you might be able to be prepared for those other laws. I think we're definitely moving in the direction of more enhanced data privacy and security, and so it's something that you shouldn't ignore, and if anything, you start getting ready now, and it's not too late to start implementing some of these, and to be perfectly honest, some of them are just really good business practices anyway, and you should definitely do that. And just so you should be aware, this Alistair McTaggart that I started talking about has already introduced another version that's going to be considered in the next legislative session that's going to provide additional rights for privacy. So
is that in California, Mike?
It's in California.
Okay.
It's in California, yeah. And everybody hopes, but there's a lot going on in Congress these days with other hearings and activities. So we're not likely to see a federal law that everybody was hoping for that was going to preempt this and make it go away.
With that, we want to thank you for listening today, and I want to thank my panelists, Amanda and Mike, and wish you a good day.